Either the judge misread what James Vitushka said, or he misunderstood, or he forgot the timing, or he didn't know what came before what, if the chicken came before the egg, or the egg came before the chicken. In this case, did James Vitushka talk about the SH/SA because that's how he said it? Either the judge misunderstood what he read, or an aide read it for him, so he didn't really read it, and the aide misunderstood, which led to the judge misunderstanding. But James Vatushka's statements and the timing of it all could have possibly led to the judge making the decisions he made as far as dismissing Justin Baldoni's claims. But I'm not a lawyer, so I'm gonna let my lawyer friend explain it to you. Let's get into it.
F around and find out. F around and find out. F around and find out. F around and find out.
Hello, everybody, and welcome back to another episode of F Around and Find Out. I'm your host, Elsie. And if I look puffy and sound stuffy, well, yes, the boy got me again. This time, though, I don't feel like I'll be out of commission for more than 2 days. You know how you can tell? You can tell when you're getting sick, when it's a 2 day situation or when it's going to knock you out. This, I don't feel like it's going to knock me out. It feels more like allergies more than anything. So I promise you, I'm not going to be out of commission. But what I can promise you is if this dismissal from Judge Liman will hold, because there seems to be some inconsistencies as to when James Vatushka, the reporter from the Daily Mail, who said in the text messages Blake was essayed because that's what he was told. But then he's like, I take it back. It's a mess. My friend over on the Clock app, Little Girl Attorney, was explaining how she was rereading the order and the judge referenced James's message as though it came before everything happened. But actually, it's a mess. So we're going to let her explain, okay?
There's a lot of speculation about whether the Wayfair parties are going to appeal the opinion and order on the motions to dismiss. And I was rereading the order specifically on the arguments regarding Sloan. And I think I found something that the judge got wrong. So the Wayfair parties had alleged in their amended complaint that after the CRD complaint was filed in December, Nathan received a text message from James Vatushka from the Daily Mail.
And for everybody just joining the class, this is James Vatushka from the Daily Mail, who was talking to Leslie Sloan throughout, everything that was going on. And he actually was the one that used the word SA, not SH, and then it spiraled into this entire thing. So this is him, just so you put a face to the name when you hear it, okay?
Sloan had told him that Blake was SA'd. James Vatushka from the Daily Mail saying that Sloan had told him that Blake was SA'd. The court interpreted this statement to have happened, the statement being what Sloan said to the reporter. The court interpreted that statement to have happened after the CRD complaint was filed, where the Wayfair parties are just interpreted this statement to have happened from the Daily Mail, saying that Sloan had told him that Blake was SA'd. The court interpreted this statement to have happened, the statement being what Sloan said to the reporter. The court interpreted that statement to have happened after the CRD complaint was filed, where the Wayfair parties are just alleging Nathan received a text message about that statement after the CRD complaint was filed. So there's a little bit of a nuance here. The judge assumed that the statement within that text message received after the CRD complaint was filed, the text that Nathan received, the statement within that text was also said after the CRD complaint was filed, because the ruling is that, well, those statements were made after the CRD complaint was filed. Sloan's not a lawyer, and it's reasonable for her to exchange these words based off of what she understands in a filing. So it's reading to me, and this is footnote 48 on page 93 of the opinion and order on the motions to dismiss. You should go back and read it, but this is where it talks about that it's plausible that there is another explanation for this, but the assumption underneath the rationale here is that the statements were made after the complaint was filed. I went back to see if I could identify when the statements are alleged to have been made, and it takes me to the James Vituska Declaration. So the James Vituska Declaration that was filed by James in a dispute, motion to compel dispute, so nothing to do with the motions to dismiss. In that declaration, he says, I never told Miss Sloan, or Miss Sloan never told me that Miss Lively was SH'd or SA'd by Baldoni or anyone else. This phrase that is found in the text message on paragraph 193 in the amended complaint, which is the text message that he sent to Nathan, he said that this phrase was not in reference to any conversation that he had had with Leslie Sloan, and that it was in reference to the allegations about the CRD complaint. So the judge doesn't actually cite to this declaration. I haven't seen anything in the order that actually references it, because he can't. I mean, the court has to decide a motion to dismiss based off of the allegations, not based off of evidence. So this couldn't technically have been considered. But it is interesting that the assumption is made that the statements by Sloan, the alleged statements by Sloan, were made after the CRD complaint was filed. Now, if it's true that Vituska filed this declaration under duress and actually doesn't believe the truth of what he said and is planning to withdraw the declaration, let's say later files a declaration stating clearly when the statements were made, that could be interesting, because it would show that one of the reasons why the judge had ruled in favor of Sloan in the motion to dismiss was based off of a false understanding of the allegation. So I don't know what that means. I don't know that that's enough for an appeal necessarily, but it is kind of interesting. I've also noticed that Vituska has new counsel. Something to look into, as in there's a reason for it. Usually lawyers don't necessarily like losing clients, so they work really hard not to lose their clients. So if there's a change in legal counsel, that usually means a change in legal strategy, or there's some other thing that is dictating that change. For example, if there's an employer-employee relationship, for example, and an employee is being sued, and the employer is indemnifying the employee and providing counsel for the employee in the dispute against the employee by somebody else. And then it comes out that actually the employee may have done something wrong, and the interests of the employer are now opposed to the interests of the employer. In that instance, it could be possible that the employer says, we're not going to indemnify you anymore, or we have diametrically opposed positions.
So
now,
get your own lawyer.
not even diametrically opposed, we just have a conflict. So you need to go seek counsel somewhere else, and then they would seek their own counsel and change counsel. So I don't know exactly what's going on here, why he would have needed to obtain new counsel. There's suspicion that he may have left the Daily Mail. And if that's the case, that does make sense why he would seek new counsel. I also find it interesting that the new lawyers that are representing him have a criminal defense background.
Yeah.
So I wonder if there is any veracity to these claims floating around the internet that he did file this declaration under duress. There might be some criminal aspect of this, that expertise is required. This part of the case that is unfolding continues to be interesting. I don't know enough, or I don't think we have enough to draw any actual conclusions about what it all means. But when I went back to reread the order today, I did catch that and clock that and think that that is interesting. If it comes out that those statements in the text messages that were referenced in the amended complaint were actually done in August 2024, which appears that that's when those discussions were being had, or anytime before the CRD complaint, then that piece of the reasoning for dismissing the claims against Sloan
it's moved.
fall apart.
Yeah. So this is me hoping that made any kind of sense to you guys. And if it doesn't, the easiest way I can explain it is while the judge did not base his entire decision on dismissing the case against Leslie Sloan, um, on this statement from James Batishka, he does state in a footnote somewhere that him saying the essay thing came afterwards. So he wasn't defaming Justin or wasn't making any false statements. But it didn't come after the CRD complaint. It actually came before. That text message or, that statement he made about Blake being essayed was definitely before the CRD complaint. So this conversation was happening, before anybody knew there was anything going on. So I don't, again, like she said, she doesn't know, which means I don't know because I'm definitely not a lawyer. I don't know that it changes the judge's decision. And again, it's not something that can be overturned. But if they were going to appeal, like we're suspecting they are, this is definitely something to kind of hang your hat on in appeal, at least on the Sloan case of it all. If an appeal is in fact, on the table. So let me know what you guys think about this. I can barely speak. My nose is stuffed. I can barely talk. And also, I've tried to schedule like a video with her, and she offered for you guys, anybody in the comments who's watching this, if you have like a law question, if you're confused about anything that's going on, if you want to get clarification on something, you guys send me your questions in my email or in the comments here or in my DMs on Instagram. Email will probably be easier just so I can gather them. But send me your law questions, what's confusing to you about this case that you need a lawyer to explain. Because I'm going to film something with her where we discuss those things and answer some of those questions for you and post it at some point this week or something down the line. So if you have any questions, like I said, please make sure to leave it in the comments. Send me an email at fafoassoc, that's ASSOC @gmail.com. But I want to thank you guys for tuning in and watching this very short episode. This was very interesting to me, and I felt like you needed to hear it from a lawyer's perspective, not just mine. So I hope it made sense to you and was clear enough. And we're going to see if this becomes, a point to stand on later down the road, and then we can revisit it at that point. But until then, I'm going to go drink my water, drink my tea, and knock whatever this is out. You guys stay hydrated as well. It's hot out here. And make sure to like, share, and subscribe if you haven't already done so. And I appreciate you. And I'll see you guys on the next one. Thank you so much for being here. Have a good one. Bye-bye.
Fuck around and find out. Fuck around and find out. Fuck around and find out.